Welcome to our presentation on the Advance Health Care Directive, whose aliases include Durable Power of Attorney for Healthcare and Living Will. Let's say you have a revocable living trust, a pour-over will, and a power of attorney for property management. What else do you need to complete your estate plan? Well, something's clearly missing. Wills, trusts, and powers of attorney deal with what you own, your material possessions, your stuff. What about your person? Since your person is quite different than your possessions, the law requires a different controlling document. Anyone who's ever opened a bill from an intensive care unit realizes that the care of your person can affect your financial status. But the care of your person is usually more fraught with emotion than the disposition of your property. Imagine your family waiting outside an emergency room after you've suffered a catastrophic accident. You're on life support. The doctor is convinced he or she can keep you going on life support, but also believes you have no reasonable chance of returning to any quality of life. Your doctor says you are in a permanent vegetative state. Some members of your family feel the most dignified and practical way to handle your situation is to take you off life support, offer comfort care only, and let nature take its course. One of your children, however, is deeply skeptical of doctors. How can the doctor be sure your current condition is permanent? In one case, a young woman who had suffered extensive brain damage was kept alive for 7 years on life support while a deeply divided family battled it out. Besides the financial consequences of continuing medical care, there's the emotional damage that results from such deep divisions among family members trying to decipher the right thing to do, trying to interpret what you would want under these circumstances. Your Advance Health Care Directive tells your doctor and your loved ones what you want. It allows you to insist that every means possible be used to keep you alive, or to say that if your doctor states you have no reasonable chance of recovery, to discontinue artificial means of keeping you alive. Or you can choose some middle ground. The point is, you've settled the argument for your family by completing an Advance Health Care Directive. The Advance Health Care Directive also allows you to appoint someone to make sure your wishes are carried out. No matter what the Advance Health Care Directive is called in your state, make sure you do your loved ones the favor of expressing what you want done with your person regarding healthcare decisions in writing and in a legally enforceable document. Then, when you are unable to speak for yourself, your Advance Health Care Directive will speak for you. That's all it's meant to do, by the way. If you change your mind and can speak for yourself regarding the care you do or do not want, your Advance Health Care Directive cannot override your expressed wishes. Also, the person you appoint to carry out your wishes must follow your written directive as your agent. The agent is not empowered to override what your directive says. Of course, your wishes must be consistent with the laws of your state. Many hospitals and healthcare services insist that before undergoing surgery, you fill out an Advance Health Care Directive if you don't already have one. That's how important they think they are. Emergency room nurses appreciate Advanced Health Care Directives. They have seen the families of severely injured young adults torn apart because there was no Advance Health Care Directive to guide them. They argue that every adult needs one. In most states, you have to be 18 or older to complete one. It's best to complete one sooner rather than later so someone can't claim you were incompetent to fill one out. In most states, your Advance Health Care Directive covers whether and in what circumstances you do or do not want transfusions, cardiopulmonary resuscitation, use of a respirator, dialysis, drugs, surgery, and diagnostic tests. If you choose not to use mechanical means or other extraordinary means to extend your life, that doesn't mean you don't want to receive comfort care, or as it's called now, palliative care. Your Advance Health Care Directive addresses that issue too. Who should you choose to make sure your wishes are carried out? Obviously, it needs to be a person you absolutely trust. Even if your agent may not agree completely with your wishes, he or she must be the kind of person who will respect them. It also makes sense to have a person who is assertive enough to speak up to authority figures such as medical professionals. Someone who lives close enough to see the situation firsthand makes sense too. Also, attorneys, and in many states the law itself, don't want your doctor or an employee of a hospital or nursing home where you're receiving care to enforce your Advance Health Care Directive. There's too much chance for conflict of interest. Attorneys generally discourage having two people serve as your health care agent. They encourage naming alternates, so if your first choice can't serve, the alternate will step in. Finally, some attorneys recommend that the person in charge of enforcing your health care wishes have the flexibility to deal with the unexpected. Discuss that with your estate planning attorney. We hope you feel more comfortable with these 4 basic tools of estate planning: wills, living trusts, powers of attorney for property management, and the Advance Health Care Directive. I also hope you recognize that you have other estate transfer instruments in place that you may not have recognized as estate planning tools. For example, life insurance, beneficiary designations on IRAs and on your other retirement plans, real estate and other assets held in joint tenancy. In our next session, we'll present a quick overview of the world of estate and gift tax. You may find it primarily of academic interest, but I hope you find it of interest. See you then.